this amendment itself is a stark violation of separation of powers. So please vote no.
Representative DeGraff.
Oh, that is really funny. Wow, I almost didn't get my hand up because I almost fell off the bench. Is that an April Fool's joke? Seriously.
It is not.
Seriously. Separation of powers. We are writing a bill. This body is writing a bill. It is up to this body to determine what we want this bill to say and what the scope of this bill is. Otherwise, we could just leave this in the hands of the judicial as described, that there's already a process to do this, and there's already a process to either suppress or to hide or whatever the terminology you want to use for that record, but we are writing the bill. And if we want to write a bill that is going to protect minors from these specific abuses, which is where, sure, maybe they don't want to just, but you also don't want to create another name identity laundering bill. This is an identity laundering bill, another identity laundering bill. And then when you compare this bill, when you get this bill in conjunction with other bills, such as the renamed 1309, for instance, talking about name changing, Mr. Chair, 1309 from last year, 25-1309 and 26-1309, largely making any parents concerned about dysphoria affirming mutilation into being called coercive control, and then you rename the bill in 26 and give it a new name to hide what the old bill was. These all tie together.
Representative DeGraff, please come back to L011.
Oh, we're there. We're already there.
Terrific.
So I think the sponsor's reasoning is really amusing. And it's fitting for April Fool's Day, because this body is writing the law. And we're saying we want the law. Hey, we agree with you. Maybe there's some times that maybe like domestic abuse, stalking, human trafficking, or credible threat of harm, maybe those should go in the non-published category specifically. We'll just step the judicial process right through it and go, hey, you don't have to be concerned about our intent here. You can just go and look at the actual words and say, that's what we wanted to protect people from. But this bill, the intent is to protect outside of that. Until we accept this, the bill is to accept outside of that. It is to this bill, this amendment limits the discussion, limits the application of this bill basically to the examples that were given by the sponsor. Now, there's a lot of reasons that the sponsor didn't really give for the actual reason of this bill, but this amendment limits the bill to basically what it limits to the initial gaslighting of the introduction. This is how we limit the bill to what the sponsor said the bill was about. The sponsors are going to reject this. What does that mean? It means this is not what the bill is about. And then we need to, if this is not what the bill is about, now we are free to speculate on what this bill is about. Because this is what's written. This would be what's written. And if you're going to not write it, now we have to speculate about what's unwritten. And sometimes things that go without saying should be said. And what this bill is about is going to have to be said, because we're trying to limit the bill so we're comfortable with it, so we can say, yeah, I think this bill is what the sponsors say the bill is about. And then the sponsor comes up, and so this is a good faith amendment, just to say we agree. We think you're telling the truth to make sure that this is what the bill is about. So we're going to put it in writing, and then you come up here and you say, yeah, that's not what the bill is about. So if we're going to reject what this bill is about, then I'd say we are free to speculate what this bill is about. Because the sponsor has told us it's not this. I recommend an aye vote on this amendment so we can actually have a conversation about what this bill is intended to do instead of going into another conversation about what this bill will be able to do, which is what the bill is likely all about.